A cop just pulled you over. You are sitting in your seat. Heart rate is climbing. Blue lights are strobing in your mirror. And before that officer says a single word to you, before they are even halfway to your window, their hand makes contact with the back of your car, right on the taillight. Just a tap, gone in half a second, and you have absolutely no idea what just happened. Most drivers sit there thinking it means nothing. A habit, an old-school tradition. Maybe they needed to steady themselves on the way up. But here is the truth that defense attorneys and former law enforcement will tell you directly when they are being completely honest. That touch is not accidental. That touch is not casual. That touch has a very specific legal purpose that could determine everything that happens to you in the next 20 minutes. And if you do not know what to do the moment that hand makes contact with your vehicle, you could be handing the officer exactly what they need to turn a routine traffic stop into something far more serious before they even reach your window. This is the kind of information most people only learn after things have already gone wrong. After the handcuffs, after the court date, after the attorney fees. I have spent months working through deposition transcripts, body cam footage, and sitting with defense attorneys who handle traffic stop cases every single week. And what I found is that the taillight touch is just the beginning. There is a complete framework that legally smart drivers use from the moment those lights come on to the moment they drive away clean. And the people who know this before a stop are in a completely different legal position than the people who learn it after. Here is what you are going to walk away with today. You are going to understand exactly what the taillight touch is, why departments train officers to do it, and the legal purpose it serves that almost no driver on the road knows about. You are going to learn the physical response that lawyers say is your single most important move of the entire stop. You're going to get the exact words to say word for word, so there is zero guesswork when you need them. You are going to understand what voluntary consent actually sounds like, so you never accidentally give it. And you are going to see a complete traffic stop play out two ways, the wrong way and the right way. So you can see exactly where most drivers lose and where smart drivers walk away clean. Everything here is 100% legal. It is backed by Supreme Court decisions, and it is used by real defense attorneys in real cases right now. Let us get into it. Here is what most people assume about the taillight touch. They assume it is a nervous habit, or they have heard somewhere that it has something to do with the trunk that officers use to check whether it was locked. They file it away as a quirk and forget about it entirely. That assumption is exactly what makes the technique so effective. The taillight touch serves two distinct purposes, and both of them are things you need to understand before you can protect yourself from either one. The first purpose is physical evidence placement. When an officer touches your taillight, they leave their fingerprints on your vehicle. That is not a side effect. That is the point. If something happens during that stop, if there is a confrontation, if events escalate in any direction that officers' prints on your car, physically anchor them to that specific vehicle at that specific moment in time. Departments began training officers to do this decades ago as a safety and evidence technique, and it remains standard practice in many jurisdictions to this day. But it is the second purpose that defense attorneys say matters most to you personally. The second purpose is what is sometimes called the startle test. The officer taps that taillight on their approach, and they are watching your reaction before you even know they are watching. A sudden movement toward the center console, a flinch, an arm jerking toward the glove box. Anything that reads as a panicked reaction to unexpected contact with the vehicle. And here is why that matters directly to you, because that reaction can go straight into the written report. Driver appeared startled and made a sudden movement toward the center console upon approach. That sentence in that report is now part of the official record. And under Terry v. Ohio, the 1968 Supreme Court ruling that established the standard for officer safety during stops, a specific and articulable observation of suspicious behavior is exactly the legal threshold that can justify extending a stop, requesting backup, or establishing what courts call reasonable suspicion of criminal activity. In plain language, your flinch can become their legal justification to keep you there far longer than the original ticket would have taken. Defense attorneys have pulled traffic stop reports where a driver's reaction to the taillight touch was specifically documented and cited as a factor in the decision to escalate. The touch is passive. The data it collects about you is anything but. So the question is not whether officers do this. They do. The question is what you do in the 5 seconds after it happens. Here's the moment where most drivers get it completely wrong. And they get it wrong because their instinct is to be helpful. The lights come on. They pull over, and the very first thing they do is start reaching. Reaching for the glove box, reaching for the center console, reaching across the seat for their bag. They are trying to get their documents ready. They want to look cooperative. They want to look like they have nothing to hide. And every single move they make is being logged before the officer has said a word. By the time that officer reaches the window, the driver has already created a record of movement that goes directly into the report. And the taillight touch, designed specifically to trigger exactly this kind of reaction, just worked exactly as intended. Here's what lawyers say you should do instead. The moment you are fully stopped, you take these steps in order. Signal and pull over to a safe, well-lit area. Turn off the engine, roll down your window, and if it is dark outside, turn on your interior dome light. Then you place both hands at the top of the steering wheel, not on the sides, not in your lap, at the top where they are completely visible to anyone approaching from the rear or from the driver's side. You turn off your music and you do not move your hands for any reason until the officer is at your window and has spoken to you directly. That is the entire physical protocol. Hands visible, body completely still, window down, dome light on if it is dark. Wait. When the officer approaches and the tail light touch happens, your physical response to that touch is the image they see when they arrive at your window. 2 hands clearly visible at the top of the wheel. No movement, no reaching, no flinching. That image directly contradicts any documentation of a suspicious reaction because there is nothing suspicious to document. There is nothing to put in the report because you gave them nothing to write about. Think about the difference this makes on paper. In the first version, the driver pulls over and immediately starts digging through the glove box. They are leaning, reaching, moving. The officer approaching from behind watches hands disappear into a compartment before they have even reached the vehicle. That observation enters the report before the first word is exchanged. Driver was actively reaching into the glove box during approach. 1 line already in the file. In the second version, the driver is sitting completely still with 2 hands clearly visible at the top of the wheel. The officer arriving at the window sees a calm driver with nothing moving. There is nothing to document. There is nothing that reads as suspicious. The stop begins at 0. Former law enforcement officers who now consult for defense attorneys are consistent on this point. The image a driver presents during approach is one of the most documented elements of any stop. Giving the officer nothing to write about is itself a form of legal protection. Hands on the wheel. Stay still. Let them come to you. Now the officer is at your window. This is the phase where most drivers either hold their position legally or give everything away in under 30 seconds. Usually without realizing they are doing it. The officer will ask for your license, registration, and proof of insurance. That is the standard opening. And your response to that request is where your exact words begin to matter. Here is the sentence that defense attorneys recommend. Good evening, officer. My hands are on the wheel. My registration is in the glove box. May I reach for it? That one sentence does 4 critical things simultaneously. It acknowledges the officer calmly and without attitude. It announces the location of your hands without being asked. It tells the officer exactly where you are about to reach before you move an inch. And it asks permission before going anywhere near a compartment. That last element is more important than most drivers understand. Announcing your movement before making it removes the element of surprise entirely. It gives the officer full visibility and full control over what happens next. And it creates a documented verbal exchange that establishes you as transparent and cooperative from the very first moment of contact. When you hand over your documents, keep it efficient and clinical. You are providing the minimum legal requirement to facilitate the purpose of the stop. Nothing more. This matters for a reason that connects directly to your legal protections, which we will get to in a moment. Now, the officer takes your documents and returns to their vehicle. This is the quiet part where most drivers make their biggest mistakes because nothing appears to be happening. Put your hands back on the wheel. Stay still. Do not be on your phone. Do not appear agitated. The stop is not over yet. And how you look while you wait still matters. Something else is happening during this window that most drivers are not aware of. The officer is running your plates. They know your driving history. They are checking for outstanding warrants, verifying that your registration is valid, and making a judgment call about what they are going to do with you. But they are also watching body cam footage reviewed in case after case shows officers glancing at the stopped vehicle repeatedly while seated in their cruiser. A driver who is visibly agitated, reaching around the cabin or looking repeatedly into the rear-view mirror gives the officer additional observations to factor into their approach when they walk back up. A driver who is sitting calmly and visibly still gives them nothing to add. Every moment of the stop is part of the record. The quiet waiting period is no exception. Then they come back, and this is the phase where casual conversation becomes legal quicksand. Officers are trained to use the return of documents as a transition point. They hand back your license, and in the exact same breath, they ask something like, "So, where are you coming from tonight? Or do you live around here? Or you got anything in the car I should know about?" These questions feel like small talk. They sound like the officer is just being conversational, maybe even friendly as a way of wrapping things up. They are not small talk. They are a continuation of the investigation by a different method. Every word you say at this stage is a potential articulable fact that can be used to justify extending the stop or initiating a search. If you mention you were coming from a friend's place, they can ask whether there were drugs there. If you mention you had a drink or two, you have just opened the door to a sobriety investigation that was never on the table until you handed it to them. Defense attorneys who handle these cases say it consistently. Drivers do not lose in the field by being guilty. They lose by talking. You are legally required to provide your license, your registration, and your proof of insurance. In most states, you are required to provide your name if asked directly. That is the complete list of your legal obligations during a traffic stop. Every other question, every single one without exception, is voluntary conversation. You do not have to participate. And here is the exact way to say so. "Officer, I'm happy to provide my documents, but I'm going to respectfully decline to answer additional questions." Say it once. No attitude, no nervousness, no lengthy explanation, no citing the Constitution out loud. Just that sentence calmly and clearly while looking the officer in the eye. This is your Fifth Amendment right, and it does not begin at arrest. It begins the moment a question from law enforcement could incriminate you. That is directly supported by Berkhammer v. McCarty. The 1984 Supreme Court ruling that confirmed your right to remain silent applies fully and completely during a traffic stop. In plain language, you do not have to wait for handcuffs to stop talking. You can exercise that right now on the side of the road before anything has escalated, and you are breaking absolutely no law by doing so. There's also a timing element here that most drivers never consider, and it connects to one of the most powerful legal protections available to you under the Supreme Court's ruling in Rodriguez v. United States in 2015. A traffic stop cannot be extended beyond the time necessary to complete its original purpose without independent justification. The mission of a traffic stop is specific. It includes checking your license, verifying registration and insurance, checking for outstanding warrants, and issuing the ticket or the warning. That is the complete list. Anything else? Asking about your destination? Asking about your evening? Waiting for a K-9 unit to arrive? Lingering at your window after the paperwork is done? Is what courts now look at very carefully. Appellate courts reviewing body cam footage ask one central question. Was the officer working, or was the officer waiting? If they are asking you about your night instead of completing the paperwork, they are slow walking the stop, and that is a constitutional issue your attorney can use. This is exactly why being efficient with your documents matters. You are not stalling. You are not being difficult. You are keeping the stop focused on its stated purpose, which is the only purpose it is legally allowed to serve without additional justification. Now comes the moment that most drivers handle completely wrong. And it is the moment that determines whether a stop ends cleanly or transforms into something else entirely. Your documents are back in your hand. The ticket or the warning has been issued. The officer is still standing at your window. Most drivers sit there and wait. They assume the officer will wrap things up and walk back to their cruiser. So they stay quiet and hope it ends soon. That patience is a mistake because while the driver is waiting politely, the officer is watching for a reason to extend the encounter. And then it comes. By the way, you do not have anything illegal in the car I should know about, do you? You do not mind if I take a quick look. This is what attorneys call the consensual encounter transition. The official mission of the stop has concluded, but the officer is attempting to move into a new voluntary phase of interaction. And the critical thing to understand is this. If you say yes or sure or go ahead or even I guess so, you have just given verbal consent to a search. That phrase you can check if you want is legally identical to signing a consent form. Whatever is found is now admissible because you invited it. The Fourth Amendment protection that would otherwise require a warrant or probable cause has been waived by your own words. There's one more thing about this specific moment that defense attorneys want drivers to understand. The consent question is almost never framed the way most people imagine it will be. Most drivers picture it as something formal and obvious, a direct request with serious language that clearly signals a legal threshold is being crossed. In reality, it is almost always casual. It sounds like the stop is already over. The officer's body language may suggest they are wrapping up. Their tone becomes lighter. They might even smile. All of that is part of the technique. The transition from official stop to consensual encounter is specifically designed to feel like it is not happening, which is exactly why knowing what to say before you are ever in that seat is the only thing that protects you in that moment. To stop this the moment it begins, you need the most powerful 6 words available to any driver on the side of any road. Thank you, officer. Am I free to go? Those 6 words are a legal tripwire. They require a direct answer. The officer must either say yes or say no. If the answer is yes, the stop is over. You put the car in drive and you leave slowly and calmly. You do not stay to chat. You do not try to prove you are a good person. The encounter is legally finished. If the answer is no or not yet, you are now being detained, and detention requires the officer to have independent, reasonable suspicion of a crime that goes beyond the original traffic violation. By asking that question, you have forced that legal reality into the open. You have activated Rodriguez v. United States in real time without needing a law degree to do it. If they refuse to let you go and ask to search the car, you do not get angry. You do not argue. You do not raise your voice or mention the Constitution. You simply state clearly and calmly, ideally, in the direction of any body camera that may be running, "Officer, I do not consent to any searches of my person or my property." Say it once. Say it clearly. And then say nothing else. Even if they bring a K-9 unit, even if they tell you that a good person with nothing to hide would not care, you remain completely still and completely silent on that point. If they proceed to search your vehicle anyway, you do not physically resist under any circumstances. Your battle is not on the side of the road, it is in the courtroom. And your clearly stated recorded verbal refusal is the anchor that allows a judge to potentially suppress every piece of evidence found from that moment forward. Now, let us see everything put together. Same road, same night, same stop. 2 drivers. 2 completely different outcomes determined entirely by what each driver knew going in. The first driver is pulled over. They are nervous, so they immediately start reaching into the glove box to get their registration ready. They want to look helpful. The officer approaching from behind watches their shoulders moving, watches their hands disappear into a compartment, then the tail light tap. The driver flinches because they did not see the officer yet. That observation enters the report before a word is exchanged. The officer arrives at the window already writing the stop in their head is elevated. The driver is chatty. They answer every question honestly because they believe cooperation signals innocence. They mention they were at a friend's place and had a couple drinks. The officer now has the thread they needed. 45 minutes later, after a search that began with voluntary consent, the driver did not understand they were giving. The stop has become something completely different from a traffic ticket. The driver never understood where they lost. They lost before the officer said hello. The second driver sees the lights come on. They signal and pull to a safe, well-lit spot on the right shoulder. They cut the engine. They roll the window down. They flip on the dome light because it is nighttime. Both hands go to the top of the steering wheel. The music is off. They are completely still. The officer approaches, and their hand taps the tail light. The driver does not flinch, does not move, does not turn around, keeps both hands visible, and keeps their eyes forward. The officer reaches the window. "Good evening, officer. My hands are on the wheel. My registration is in the glove box. May I reach for it?" The officer says yes. The driver retrieves the documents slowly and deliberately and hands them over. Hands return to the wheel. The officer walks back to their cruiser. The driver sits still with hands visible and waits. The officer returns and hands back the documents. Then comes the pivot. "So, where are you headed tonight?" "Officer, I am going to respectfully decline to answer additional questions." A pause. "Is there anything in the car I should know about?" "Thank you, officer. Am I free to go?" The officer confirms yes. The driver leaves. Stop completed in under 8 minutes. No search, no self-incriminating statements, no voluntary consent to anything. Nothing in the report except a routine traffic stop that ended exactly the way it was supposed to. The second driver knew the framework. That is the only difference. Now, there is one more step, and it is the step that almost no driver ever takes, and it is the one that can make or break everything if the situation eventually ends up in a courtroom. The moment you are safely away from the scene, within 5 to 10 minutes, you pull into a parking lot or a gas station. You open the voice recording app on your phone, and you create what attorneys call a contemporaneous record. You state the date, the time, the exact location of the stop, the officer's name and badge number if you were able to see it, the stated reason for the stop, every question the officer asked, every answer you gave, whether and where they touched your vehicle, whether a search was requested, what you said in response, and how long you were sitting there while the officer was in their cruiser. Because that timeline is directly relevant to whether a Rodriguez violation occurred. All of it on record. Time-stamped. Voice memos are automatically time-stamped on every major smartphone platform. In court, a time-stamped recording created within minutes of an event carries real weight. It demonstrates the account was created while details were completely fresh, not reconstructed weeks later from a fading memory. It can be compared directly to the officer's written report. Inconsistencies between the two become tools for your defense. Accurate matching details become corroboration. The driver who does this walks into a potential courtroom proceeding actually equipped to fight. The driver who does not is standing there with their word against a professional written report filed the same night by a trained officer. Think about the reality of what happens in a courtroom months after a stop. The officer testifies from a detailed, professionally written report created the night of the incident. While every detail was fresh, every observation is documented. Every statement you made is on record. Every movement that was logged during approach is in the file. Without your own contemporaneous record, you are asking a judge to accept your recollection of events against a documented official account. With a time-stamped voice memo, your attorney has an independent record created at essentially the same time as the officer's report. The playing field changes. Details that contradict the official report become discoverable. A timeline that shows the stop ran far, longer than the paperwork required, becomes evidence of a potential Rodriguez violation. The documentation step costs you 5 minutes. The absence of it can cost you everything. Here is your complete framework pulled together. When the lights come on, pull over safely. Cut the engine. Roll the window down. Turn on the dome light if it is dark, and put both hands at the top of the steering wheel. Do not reach for anything. Do not move. When the tail light tap happens, do not flinch and do not react. When the officer reaches your window, say, Good evening, officer. My hands are on the wheel. My registration is in the glove box. May I reach for it? Keep every document handoff efficient and clinical. When the questions shift beyond the paperwork, say, Officer, I'm going to respectfully decline to answer additional questions. When your documents are back in your hand, say, Thank you, officer. Am I free to go? If they ask to search your vehicle, say, Officer, I do not consent to any searches of my person or my property. And when the stop is over, document everything within 10 minutes while it is still completely fresh. These steps together form a complete legal framework. They are backed by Supreme Court decisions. They are used by working defense attorneys in active cases right now. And every single one of them is completely legal to use at any traffic stop in any state under any circumstances. In just a few days, the next video goes up on one of the most legally dangerous scenarios a driver can face. What happens when an officer claims they smell marijuana coming from your vehicle? That claim bypasses almost every protection covered here and is used to justify searches in ways that courts are still actively debating. Most drivers walk into that moment completely unprepared and have no idea what their rights actually are in that specific situation. Subscribe and hit the notification bell right now so you do not miss it, because that one is essential viewing. If this changed how you think about your next traffic stop, smash the like button right now. It takes 1 second and it helps more people find this information before they need it. Drop a comment telling me which one of these tactics you had absolutely no idea about before today. I read every single comment. Stay sharp, stay protected, and stay safe out there every single time you get behind the